Good luck, guys.
All right, good morning. I'm Tara McKeown from the IFA, and on behalf of the IFA International Committee, we welcome you to this webinar on bringing your brand to the United States. We have some amazing speakers here today, and I'm excited to introduce Ray. Over to you.
Oh, well, thank you very much, Tara. Yeah, I'm Ray Hayes. I'm the managing partner of Fran Launch USA. And our firm has worked quite a bit with this topic of bringing international franchisors into the U.S. market. Additionally, I've written a few papers and articles on the topic, and I'll share some of the best practices. Let me just bring up my slides here. And I will.
Before we get into that, Ray, if I
Yeah.
could just take a moment just to give everyone brief introductions of all the panel members and welcome
Please.
everyone and give everyone an overview of what to expect during the program. So my name is David Azrin. I'm a franchise attorney with Wirsch and Goering. It's an international corporate boutique law firm located here in New York City on Wall Street. I'm going to be acting as the moderator today. And first, I want to thank the International Franchise Association, and in particular, the International Committee, and in particular, Tao Xu, who is the Director of Programming of the International Committee of the International Franchise Association for his initiating and helping to organize this program. Tao is a partner and franchise attorney at DLA Piper. So as I mentioned, I'll be acting as the moderator, and I'll give you a brief introduction, and then I'll give a brief introduction for each of our panel members, and then we'll go through the program. We're going to do our best to leave time for questions and answers at the end of the program. You can post, but during the program, you can post questions or comments in the chat box on the Zoom, and we'll try to answer those either during our discussion or definitely after. So just again, my name is David Azrin. I'm a franchise attorney with Wirsch and Goering, represent a number of non-U.S. franchisors, helping them to set up their systems here in the United States from a number of different countries and different industries. I'm currently chair of the New York State Bar Committee on Franchising, Distribution, and Licensing, and got my law degree from Michigan and from went to Stanford undergrad. And I'll introduce briefly our other panel members. So Ray Hayes, who you just heard from, he is the founder and managing partner of Fran Launch USA. It's a team of franchise experts help international franchisors expand into the U.S. That's what they're dedicated to doing, and they're experts in that area. He has over 34 years of experience developing and supporting global franchises with experience in more than 50 different countries. His areas of specialization include operations launches, franchisee training and support, franchise development, and brand marketing. He holds an MBA from Thunderbird School of Global Management and a BS International Affairs from Georgetown. We'll also be hearing from Fred Corso. Fred is a CPA with the U.S. accounting firm Citrin Cooperman. Citrin Cooperman, I can tell you, is known as one of the leading accounting firms in representing franchisors and with significant experience representing non-U.S. franchisors setting up their systems here in the U.S. Fred is the partner and leader of Citrin Cooperman's international tax practice, focusing on the complexities of U.S. international taxation, global operational and entity structuring, mergers and acquisitions, and other considerations that arise in the cross-border environment. He has a MS MBA from Northeastern and more than 25 years experience in international tax work. And last, we'll be hearing from Andrew Kidd. Andrew is the CEO of Poolworks USA, which is the American arm of the largest franchised global pool and spa service and retail network. And he's going to be talking with us about his personal experience as a non-US franchisor in helping to bring his brand to the US. So I'm really looking forward to that. Andrew's originally from New Zealand. He joined Poolworks in Australia in 2012. He was the chief operating officer there, and then he helped to bring the brand to the US. Poolworks came to the US in 2015 by acquiring a couple other existing systems, and now it's grown to, I know it's more than 60 locations across the country. And Andrew himself relocated to the US in about 2019. He's in Dallas, Texas, and he's going to share his experiences with us. So the order of the program will be first, we're going to hear from Ray, who's the expert consultant on bringing your brands to the US. Then I'm going to be talking a little bit about the legal issues. Then we're going to hear from Fred, who's going to talk about the international and US tax issues that face the foreign franchisors. Fred from Citron Cooperman. And then Andrew from Poolworks is going to share his experiences. And then hopefully we'll have some time for questions and answers. So with that, again, I want to thank the International Franchise Association and Tao Xu, and thank all the panelists. And I'll turn it over to Ray of Fran Launch USA.
All right, thank you, David. Thanks for the kind introduction. I'm very excited. Great group of panelists, experts, and let me just go ahead and dive in here. I'm going to share my screen, and there. Just to confirm, you see the IFA logo there?
We don't see it yet.
Okay. One moment.
There we go.
There we go. All right. Okay. And there we go. All right. Thanks again, and wanted to just really quickly go over what I'll be talking about here. I'm going to be focusing on pitfalls and best practices. I'm going to cover kind of back to back, what are the 5 most common mistakes for international franchisors in their launch. And then I'll talk about the corresponding best practices. After that, I'm going to take a case study of 5 UK based franchisors who entered the US around 5 years ago, or in various stages, and look at what happened over the last 5 years to those franchisors. All right, so pitfall number 1. It's regulatory know-how can be a real challenge for any new franchisor, American franchisors included. So what I've realized in talking with and meeting with international franchisors is that some of them really didn't understand US franchise regulations, or worse, they simply ignored them. I've seen, at major international trade shows in New York, for example, cases where franchisor representatives will be handing out financial information on the US of their franchise and what can be expected in the US, which is a flagrant violation of US franchise regulations. This type of lack of understanding, often results in number one, a failed launch, but even worse, very expensive litigation. So my advice here as a best practice is get your legal expertise engaged and do it early. You want to hire an experienced franchise attorney. Often some emerging franchisors will hire a business attorney or someone who doesn't have deep franchising experience. So that's number one, is get that expertise early in the process. And I say that because some of the key accomplishments that you want to make in the early stages are going to require advice from an attorney. Some international franchisors that said, well, I'm going to wait until my FDD is done, and then I'll bring in my attorney. That's not the right approach. In the early stages, you're going to need to be looking at trademark checks. You want to understand state regulations, especially if you're identifying a specific state that you want to come into. You want to be sure that the website and marketing that you're using in the United States is compliant with regulations. You want to be sure that you've set up the appropriate corporate identity or corporate entity to manage your operations in the U.S. and mitigate your liabilities. And of course, finally, most of you will know you're going to eventually need to set up your franchise disclosure document, FDD, and your franchise agreement. So another pitfall that I've seen time and again is that franchisors often underestimate the capital requirement and the time that it takes to launch a U.S. franchise. I've had more than one franchisor say to me, reflecting back, our entry took twice as long as we expected and cost, twice as much as we had budgeted. So, what's a realistic budget? Okay, I will give a possible range here, and it may vary by franchisor, but typically what we see is about $150,000 to $500,000 or more to get your US launch done right. Okay, that's not all legal fees. That includes a lot of the administrative setup, getting the right people in place, etc. But and I should mention here, this does not include pilot units. If you're setting up pilot units, you need to look at that as a separate budget, because obviously that cost will vary completely depending on the franchise brand. So, in the end, what I'm saying is, if you think you're going to come into the United States for under $100,000, I would beg to differ. You do not want to come in undercapitalized on this project. So what I would recommend as the second best practice is budget conservatively and set realistic timelines. Okay, what you want to do is have a business plan with a 5 to 10 year horizon and a corresponding budget and growth plan. In terms of legal expenses, I talked about the bigger budget, but you can expect to spend about $30,000 to $50,000. That will depend on many factors, including the type of strategy that you choose to sell franchises. But one thing, again, that is often overlooked, that the legal costs, based on some of the budgets that I've seen, represent only about 15 to 20% of the U.S. program launch to set up the franchisor. Again, you need to look at the bigger cost of personnel, overhead, etc. Pitfall number 3 and I've seen this unfortunately several times as well, where international franchisors decide to sell franchises without setting up company-owned pilot operations. I'm a huge fan and advocate of setting up your own operations, company-owned, to test your concept in the market. And otherwise, what happens is it leaves that testing in the hands of potentially inexperienced franchisees or master franchise partners. And what you don't want to do is make your first franchisees become the lab rats for you. Okay, I've seen that backfire in bad ways that include substantial litigation. So related to that, my advice would be set up at least one company-owned pilot operation. Some successful franchisors set up two or more. The reason for this is that the pilot is an essential part to testing and showing proof of concept. These activities need to be in the hands of the international franchisor so that you as the franchisor are learning the hard lessons. You're going to make mistakes, but you don't want, you want to learn from those and then apply that know-how once you start selling franchises and supporting those new franchisees. Pitfall number 5 that I've seen is that oftentimes franchisors understandably have more confidence in their own team members, their international executives to run their US operations. The challenge with that, and first of all, I want to say, I'm not saying that you don't send any of your people over to the United States, okay? There is something to be said about, knowledge transfer training and assisting whoever your partner operations are in the US. But these international managers often don't understand US franchise regulations and, more importantly, labor laws. I've seen blatant labor law violations that have been, completely avoidable, that were caused by international managers coming in and hiring people and not understanding the best practices for in terms of labor laws. So obviously, when mistakes happen like this, again, you have the real risk of litigation. And the other thing that you need to realize is, when you're sending international managers into the US, if they're coming in to do, a few weeks of training or whatever, that's fine. But if you're trying to have them run the operations, they could run afoul of US worker visa regulations. I've seen that happen as well. So my best practice coming out of this is hire experienced US managers and contracted executives. And what I mean by contracted executives, that's going to include, your legal team, marketing agency, consultants like me, and other subject matter experts who are American and understand and have experience and depth in the US market. Again, it's okay to bring in your experts, but not as a long-term solution. Pitfall number 5. Some franchisors thought that they could just begin selling franchises in the US and do it from abroad. This is something where the reality is that you can't effectively manage day-to-day operations in the US from your headquarters overseas. The real challenge to that, number 1, is going to be time zones, and then just other factors of connecting with your franchisees, connecting with your team in the US, you do need, some type of leadership there. And I would clarify here that Canada will be the main exception to this, because Canadians, of course, there's fewer language barriers. They have the same time zones as the US. So there have been some examples of Canadian franchisors who have managed their US franchise operations from Canada and have done it successfully. And that's been for several decades. There's lots of examples of that. So the best practice for most franchisors is, what I would say is set up a small branch office. And I'm not talking about, major overhead. I mean, you shouldn't be spending, $20,000 a month on primary office space. You can start small. A shared office in the US, that's perfectly sufficient. Your US team could be located remotely across the US. I have several franchisor clients who do manage their operations and franchise development remotely. But the reality is trying to manage that team from overseas seldom works. And what you need is that leadership on the ground in the US to make the calls to in terms of decision making, in terms of meeting with potential franchisees, etc. So let me step back and give some examples of some franchisors and what they've done over the last 5 years. I'm not going to mention names. And by the way, I'm not picking on the British. This was based on an article I wrote in Global Franchise Magazine, where I took 5 different franchisors in different categories. And I interviewed them about their experience coming into the US. And this was February 19th, so 5 years ago. Over the summer, I was thinking, well, what happened to those franchisors since I spoke to them? So I went back and I looked at the numbers and I looked at their strategies. And this is kind of a summary of what I discovered. So there's a lot in this chart, and I've just gone through and explained who the UK franchisors were in terms of categories. What we've seen here is, each of these franchisors, they came into the US at different points. They used different franchise strategies, and they had different experiences, between 2019 and 2024. Now, the reasons for their success or failure, there could be many, many factors, so it may not have been their strategy specifically. Of course, we've had a pandemic between 2019 and 2024, so that comes into play. But I did want to look at those ones that did succeed in growth, or at least maintaining a decent number of units, and those that really didn't, weren't able to. And in summary, I mean, you can kind of see it right there. Those that employed pilot units were more successful. And once they set up pilot units, they went into a strategy of starting with single unit deals, and often expanding that into multi-unit deals. What we see in terms of the ones that didn't succeed is those who came in using a master franchise strategy or a joint venture strategy. The challenge is some franchisors think they can come in and just sell master franchises. I've heard people say, oh, we're going to sell a master franchise in every state. That's not going to work, I can tell you right now. So master franchising, might eventually be part of the evolution of your franchise in the US. but it shouldn't be a starting strategy for you. And I would also just mention, and some of my attorney colleagues might explain a little later, the other strategy similar to master franchising is what we call an area representative agreement. And joint venture, I should mention, I've seen several cases where there's been disputes between the joint venture partner in terms of performance. And when there is a dispute, there is a highly likely chance that if it's a foreign franchise brand and a U.S. joint venture partner, the U.S. joint venture partner usually wins. And oftentimes, I've seen this, the foreign brand loses control of their franchise and their brand in the U.S., which is not something that you want to happen to you. So I just wanted to sum up here with some of the information and where you can find it. Please reach out to me. I'm more than happy to share our experience with you. We have, my firm actually has represented multiple brands, and in fact, our offices have served as the initial headquarters, U.S. headquarters for some franchises that are emerging. We still, it's been about 5 brands that we've had in our offices and who have used our office as their U.S. branch address, and we are currently represent 2 New Zealand concepts here. So happy to share our experiences with you. Please pick up the phone, send me an email. Happy to connect. Thanks so much for your time, and I'll turn it back over to David. Let me get out of presentation mode. There we go. David, you hear me?
Yes, I can.
Okay,
Thank you,
great.
Ray. That was such a terrific overview because you really touched on all of the issues that face the non-US franchisors coming into the US. So with that, I'm going to dive just a little bit deeper and explore some of the nuances of the legal issues and the legal framework. And then, as I mentioned, Fred Corso from Citron's going to talk about the tax issues, and then we'll have Andrew Kidd. So let's dive into the the legal issues. All right, and you can see my screen?
Yes.
Okay, terrific. Okay. So let's just first talk about what's the general legal framework that faces non-US franchisors coming into the US. So, and this program is intended for non-lawyers. So I'm going to be giving an overview in non-layman's terms without getting into there are a number of technicalities and complexities to the law, but I'm going to be just giving you the general overview, what we're talking about. So in the US, you have 2 sets of regulations. You have one set of the federal regulations that obviously everyone in every state has to comply with. And then certain states, there are 13 states that have a registration requirement where the state regulator has to review and approve your right to sell franchises in that particular state, and has to approve your franchise disclosure document. And they may have some slight nuances or variations that with respect to their particular state law, and those are usually addressed as a simple add-on, a tag, an addendum to the franchise disclosure document. So what's the general legal framework? So you have, again, a set of federal regulations issued by the Federal Trade Commission. And those regulations require that 2 weeks before you have the franchisee sign anything or take any of their money, you have to provide them with a detailed franchise disclosure document, which contains, usually these documents can be 300 to 400 pages long, because they include the following things. They include a detailed description of everything about the franchisor, their experience, any litigation, a detailed description of the initial fees, all of the ongoing fees, a detailed description of what are going to be the startup cost for the franchisee in setting up their location. And this description, it's important that it's a detailed description. It breaks down each category, the rent cost, the build out cost, the initial inventory, the equipment, the training. So you really have to give the franchisee an idea of how much is it going to cost for them to to start up. You have to describe all of the assistance you're going to provide. You have to describe the training program. And here again, it's incredibly detailed. You have to give a description of every subject you're going to cover in the training, how many hours on that subject, where it's going to be located, who's going to be providing the training, and the documents you're going to provide as part of the training. You have to describe all of the required purchases, if you have vendor relationships, they have to use particular vendors for, let's say, their POS system. You have to describe your trademark, the status of your trademark rights, which we'll get to in a few minutes. You have to describe the number of outlets you've opened so far. You have to give the contact information for all of your existing franchisees so that the prospect can contact them. You have to give any information in writing about any statements that you're going to make during the sales process of how much money the franchisees can make. And we'll get to that. We'll dive into that a little bit deeper in a few minutes. You have to also attach all of the agreements that they have to sign, and you have to attach an audited financial statement of the entity that is selling the franchises. And all of this information has to be updated each year as long as you continue selling. In theory, you could just start selling for 1 year. You could sell 10 units during the first year and then not sell any additional units. If you're not selling any additional units, you don't have to keep updating the franchise disclosure document. It's merely a sales tool for future franchisees that you're trying to sell to. So at the federal level, this franchise disclosure document is not filed anywhere, and it doesn't have to be approved by any federal agency. But it is a legal requirement, and the Federal Trade Commission does have the right, if it gets a number of complaints about a system, to take action by the federal government. They've done that only on rare occasions, very egregious issues. But also, many states have laws, unfair trade practice laws. Sometimes they call them little FTC acts because they incorporate all of the federal unfair trade practices regulations. And so people can sue, a franchisee can sue under those state unfair trade practices laws. In addition, now you have the second level of regulations, which is at the state level. And as I mentioned, 13 states require that this same federal franchise disclosure document has to be filed with the state, reviewed and approved by a state regulator. And they might have some minor nuances. There are other states that have notice filing requirements, which I won't get into. But of the 13 states, we're talking the major ones. So you go Hawaii, Washington, California, North Dakota, South Dakota, Illinois, Maryland, Virginia, New York, Rhode Island, Indiana, Michigan are the main states that have these registration requirements. So that's the general legal framework. Okay, so then the next question people normally ask me is, okay, how do I avoid all of that? So the answer is here are the possibilities. So the possibilities are you could simply just open company-owned locations in the US. You could establish a US company and just set them up. The best example is Starbucks. Starbucks system is not a franchise system in the US. Every one of their locations is the Starbucks out of Seattle is signing the lease. They're hiring the employees. They don't have to deal with any of the franchise regulations. The other way you could try to avoid all of the franchise legal requirements, is set up the system in a way that gets rid of one of the three elements of what is considered a franchise. So a franchise is where you give the right to someone to operate a business using your trademark. That's element number one. Number two is you charge some kind of fee or payment for that right. Typically, it's an initial franchise fee and then a royalty, but it could come in other forms. And then the third element is you're providing some kind of significant assistance or control. So there are systems that if you have you could set up a system where you're not charging any kind of fee up front or any ongoing fee, except for you're charging for the product that they have to buy. So one example is the Tasty Delight frozen yogurt system was on a license model. They didn't charge the licensees any initial franchise fee or ongoing royalties. The only way they made money was by selling the licensees the wholesale, the product, the formula for the frozen yogurt, and it has to be sold at a wholesale price. So that's one way. Um, the other way is to not require them to operate under using your trademark. So you could let them operate under whatever name they wanted. Another way is where if you have an investor in the US who is not actually operating, they are more of a silent investor, then their investment might not be considered a purchase of a franchise because they're not operating the business. I often get asked, well, can I just set up each location as a joint venture, have the franchisee will really just be a part owner of that location? A lot of people have thought of that, and the short answer is it doesn't work because that person is qualifying for all of the elements of a franchise, right? They're paying money for the right to use the mark. They're getting substantial assistance and control. So there are state advisory opinions saying that that really does constitute a franchise. What about some of the federal exemptions? There are some federal exemptions from the franchise federal sales, franchise sales requirements and regulations. There is a thing called the single trademark license exclusion. It's not, it's not specifically referenced in the regulations, but it is referenced in the statement of principles of the federal regulations. And there are a number of FTC advisory opinions on it. And that basically says if you are just issuing one license to one entity, for the entire for the United States. It could be part of the United States or the entire United States, but you can't be issuing licenses for different sections of the United States. If it's just one license for the US, then it may qualify for the single trademark license exclusion at the federal level. Federal regulations also have an exemption for a large franchisee investment where they're investing, it's approximately $1.5 million, or a large franchisee that's going to be investing approximately $7 million. So these exemptions just may not fit what you're planning to do. And even if it qualifies for the federal exemptions, you still have to keep in mind each of the state regulations and requirements. And some of those states they don't have the same exemptions. So while the federal exemptions might work in the non-registration states, in the registration states, which are some of the largest states in the US, including California, Illinois, New York, these exemptions might not work. So Next question, some people ask me, and they ask me in a lot of different ways. So what happens if I don't comply? Yeah, some bad things can happen. So in some states, it's actually criminal to sell franchises without complying with their state franchise sales laws. Um, in uh, in many states, as I mentioned, there are these state laws. Even states that are not registration states, they have these little FTC acts where the franchisee can sue you. And all of this only matters when things go badly, if a franchisee is not successful. And they've now invested, maybe could be their life savings to do the build out, cost hundreds of thousands of dollars, the inventory. They've taken out a loan, they've signed a lease. And if the business doesn't do well, they're looking for somebody to blame. And so they're going to, if they have a hook, if you give them a weapon, so to speak, against you, that you didn't comply with the disclosure laws, then they'll look to try to put blame on you. And they'll they can bring a private cause of action. Again, if they're in a registration state that has a registration requirement, one of these large states, and even if it's not a registration state, they might have a cause of action under one of these unfair trade practice laws. And they'll be arguing that they wouldn't have gone into the business if they had known all of the information that they were supposed to have been provided and they had gotten everything that they were promised, and they can get additional damages and attorney's fees. It's important to know some states impose, especially in the registration states, impose personal liability. So it's not just your company or U.S. subsidiary that could be held liable. It would be the people involved, the individuals involved can be sued personally. And the other consequence is if the state regulator takes action against you for selling franchises in that state without being registered, then when you go to sell additional franchises in the future going forward, you have to disclose that regulatory action and that in the disclosure document to every single prospect. And that just looks bad and may make it more difficult, for you to sell additional franchises. So first, what are the recommended first steps? So as Ray alluded to, it's super important and highly recommended. It's not legally required, but it's highly recommended to open a company-owned location. And I'll just review some of the reasons that Ray already touched upon. You want to figure out if the business works in the U.S. Yes, it may be successful in your home country, but the customer tastes are different. Pricing is different. You may want to make changes. To sell franchises, how can you sell a franchise in the US without being able to take that prospect to an operating location in the US that can see it operating? Another issue, as I mentioned in the disclosure document, you have to give this detailed description of how much it's going to cost the franchisee to open, to start up, to sign the lease, to do the build out. How can you possibly give accurate descriptions of what the startup costs are in the US if you've never done it yourself? Also, another problem, which sort of Ray alluded to, what happens, it's just human nature, is if you have a franchisee as the first location in the US, it's just human nature, that person starts to believe that it's their brand in a sense, that they're the ones who brought it to the US, that they made all the changes that were necessary, for it to come into the US. So it gives rise to this feeling of ownership by the franchisee. And then again, if things go badly, as Ray alluded to, the franchisee can say, hey, I brought this to the US and this is really my brand. So these are just some of the reasons. Again, it can be done, and I've had some clients who have established franchise systems here in the U.S. Without a company-owned location. It is possible. It's very difficult. I've encountered these issues with the first franchisees, starts to take ownership. We have to have a lot of legal language and pushback on that. But it can be done, but it's definitely not the recommended way to go. Preparing the franchise disclosure document, some common questions I get. Can I use the franchise agreement from my home country? The answer is yes. And because some of my clients they're so comfortable with the franchise agreement they've used. Let's say it's in the UK, it's in English, and it's or in Australia or in Canada. They know that document. They're comfortable with it. I will take it and I'll Americanize it for them. And so that can be done. It oftentimes ends up being about the same amount of work as if I started from scratch, but it can be done. Another question I get is, okay, I mentioned in the disclosure document, you have to give any revenue figures for that the prospect can make, because that's one of the first questions the franchisee is going to ask is, how much money can I make? The franchise regulations say that if you're going to say anything about how much your existing locations are making or any projections, you have to put it in writing with all of the appropriate disclosures and disclaimers in writing in the item 19 of the disclosure document. If you don't put those figures in writing, then the rules are you simply cannot say anything about how much money your locations are making, either in your home country or in the US. And this goes totally against human nature because it's the first question the franchisee asks, and you want to sell the franchise, but you have to bite your tongue and say, I simply can't give you that information. You can go and talk to the franchisees yourself. You can look at the locations, but I can't give you that information. Well, about less than half of franchisors do provide that information in their item 19 disclosure, but more than half of them do not have that information in writing for whatever reason. So related to that, with foreign franchisors, one of the first questions I get is, well, can I just use the revenue figures from my home country? The FTC in advisory opinions has said, no, you can't. It'll be too misleading and inapplicable to the US. So the only information you could give is if you start company-owned locations in the US, then you can put that revenue information in writing in the item 19 with disclaimers that these are company-owned locations. And then once you have franchise locations, you can put that information. What's the best advice for preparing the disclosure document? First, my biggest piece of advice is go get copies of your competitors' disclosure documents. They're all available because they're filed with the state agencies. And the state agencies have their own sites, and now there's now a national, it's called the EFD site run by the Securities Administration. It's an electronic database, and you can get those disclosure documents. That's where you'll see what your other competitors are doing. And that's important because your customer is not the consumer. Your customer is a prospect who is looking to buy different types of systems. They may be looking at several different systems. So your competitor is, you're going to charge a certain initial franchise fee. You're going to provide a certain amount of training. Now, this prospect's going to be looking at another system that maybe charges a lower or a higher initial fee. They might provide less or more training. They might have different experience. So that's your competitor. You want to look at the disclosure documents from your competitors. It's really incredibly useful. You want to consider using a franchise consultant. There are a number of them that specialize in that. Ray is an example, and there are others. You want to use an accountant who's experienced doing franchise audits and understands the importance of the timing of getting the audit done for purposes of the state registrations. So a firm like Citron Cooperman, who's experienced in this industry. Recommendations for the corporate structure, you want to definitely set up a U.S. entity. And you want to make sure in your dealings with the prospects and with vendors, all of your emails are going out under the logo, the signature block of that U.S. entity. You want to form a new entity because for liability reasons, tax reasons, but also because you have to give the audited financial statement of the entity that is selling the franchises. If you're selling the franchises from your foreign entity, that means you now have to do a U.S. audit of your entire home country business, which is not really a workable scenario. So you set up a U.S. entity that's going to be the seller of the franchises. Then if the whole U.S. franchise idea goes badly and you want to close up shop, you just close up that entity and you protect your mother country location and entities. You might form separate subsidiaries. Um, Recommendations for internal structure. Um, you're going to have you need to have people on the ground, as Ray mentioned, who are responsible for different things. Somebody's got to be the person helping to prepare this U.S. disclosure document, making all the decisions about the system, how it's going to be set up. You're going to have a separate team who are going to be selling the franchises. You could do it in-house. You could hire somebody, staff in the U.S. who's an employee, and then plus some kind of commission arrangement. You could use a franchise broker to find leads. They just find the leads, and then you complete the sales process. Or you can get a franchise sales organization that handles the entire process, finds the leads, does the selling right up to the signing. They charge more, the franchise sales organizations charge much more for those services. Oftentimes, it's almost the entire initial franchise fee will be eaten up with their fees. You're going to have separate people, though, that have to be providing the training and the ongoing support. And if you have company-owned locations, you might have to have a separate manager for those people. Let's talk about the protecting the brand. Protecting the brand. So this is critical, obviously, because you're bringing your brand to the U.S. The important thing to know with respect to trademark rights in the U.S. is that trademark rights, generally speaking, are determined by who was using it first, not who was registered first. So you could, it happens often, have a situation where you go and you register your mark and nobody else is registered and you get the registration. And then you find out later that somebody has been using the mark for years in another part of the country, and it's the same mark. If it goes to court, who wins? The person who was using it first. Doesn't matter that you got the registration first. So what's the purpose of the registration is an often question I'm asked. And the question is mainly to serve as a deterrence to other people, so that if somebody's doing their homework, they're thinking of using a brand, they'll look through the trademark registrations, they'll see that somebody already has it registered. Also, the registration gives you certain presumptions that can be helpful in a litigation. So as a non-US franchisor, what's the recommendation? First, you want to do a search, not only of the registrations, but also of the internet, Google search, and you can have a service that'll help you to do a more comprehensive search to see if anybody's using the brand. And assuming there's nobody who's using it in your particular area, then you want to, as soon as possible, file a trademark registration application. Even before you actually start using it, the U.S. trademark laws allow you to file what's called an intent to use application, or you can file an application based on your foreign registration, which is equivalent of an intent to use application. But you do have to, under U.S. law, provide evidence within a specified period of time that you have been actually using it and you've started actually using it in the US. For an intent to use application, it's 3 years. So you get a little bit, you can start the process, and the trademark law is set up. This is one of the exceptions to the usage wins first rule, is that if you file the intent to use application, then a year or two later you provide evidence of actual use. It's a retroactive, the law says it's presumed that you were using it from the time that you filed that application. So you get a little bit of advance, a couple extra years in terms of a jump on the game. Common mistakes the clients get into, non-US franchisors, into legal problem in the US, as Ray alluded to. The biggest one is making statements about revenues. Again, it's just human nature. It's the first question they ask, and it's human nature. You want to tell them. If you don't have it in writing in your item 19 in the disclosure document, you can't say anything. Another common legal problem is franchisors get too involved with choosing the locations for the franchisees. It's a trade-off. You want to help them, but if you help too much, then you can be blamed. If things don't go well, they blame you for choosing the location. So you try to let them be independent and find possible locations themselves and then bring them to you. The other common legal problem is non-US franchisors, they get excited and start selling in states where They're not yet registered. Again, that causes regulatory problems and potential civil liability. And the last one is employee issues is also at the top of the list in terms of making sure that anybody that you send here not only complies with the visa requirements, but that you're complying with the wage laws, unemployment compensation, workers' compensation laws. And some non-US franchisors try to get around it by saying that the person they're sending is a quote unquote independent contractor. There's a distinction in the US law between an independent contractor and an employee. There's different legal requirements for each of those. Um, it's there's not a hard and fast line between an independent contractor and an employee. There are a number of different factors that are considered. This is something where you need to consult with an advisor, attorney, or accountant to make sure that you're properly classifying the people that you're sending, whether as employees or independent contractors. Common mistakes from a business point of view. Again, not opening the company locations. It can be done without doing it, but it gives rise to all these problems that Ray and I have both mentioned. Another issue is, which Ray also alluded to, choosing the right first franchisees. The first franchisees become your spokespersons, your salespersons, because the second question after the prospect asks how much money they can make, they ask, can I go see one of your locations and can I talk to one of your franchisees? If your first and second franchisees had a bad experience and they're saying negative things about you, it could kill your efforts to expand in the US. Again, in the disclosure document, you have to list the contact information for each one of the franchisees. So the prospect has the right to just contact those people without you even giving your permission. So you want to choose the right people for the first couple of systems. And the other business problem, as Ray alluded to, is not having that system in place here in the US to provide the support. With that, we covered a lot of ground on legal issues, and I'm going to take a breath. And now I'm going to turn it over to Fred Corso at Citron Cooperman, and he's going to talk about some of the tax issues that the non-US franchisors face coming into the US.
So hopefully everyone can hear me, and I assume you can see my screen, but just confirm for me that that's true. Awesome. All right. Thanks, everyone. So again, just to help put a little bit of context to things, I am an international tax partner, and my principal area of focus, although not specifically and exclusively on matters of franchising, it is on international taxation, inbound and outbound, and in particular, transaction-related matters, tax legal entity structuring and whatnot. So the things that we're going to talk about in connection with U.S. tax, consider this to be, I'll call it awareness discussion. And so I'm going to touch on some high-level topics. We could go on for, well, an entire career about the things that we're going to talk about today. So earlier in the discussion, comments were made that as a general rule, for various reasons, it is not customary for a franchisor to enter the U.S. directly by reason or by way of the foreign or non-U.S. franchisor entering into agreements with franchisees directly. The general comments have been that the establishment of a domestic legal entity is really the better way to go, or the preferable way to go, for various reasons that have been discussed. However, understanding the distinction between how a foreign corporation and a domestic corporation are taxed under the U.S. tax regime is important for a number of reasons. So let's just touch on that for a moment. A foreign corporation is generally only subject to tax in the United States to the extent that it has certain types of U.S. source income. So generally speaking, the U.S. can only tax income that has U.S. source. And its paradigms for doing so are similar to those of most other foreign jurisdictions, particularly those that are OECD members, but there are distinctions and nuances. So a foreign corporation can be taxed on what we call its effectively connected income. So if it has business income that is considered to be connected to a U.S. trade or business of that company, and if that U.S. trade or business income can be considered as connected to, let's say, a fixed place of business, I'm oversimplifying, then that foreign company can be subjected to U.S. corporation income tax on that taxable income that is considered to be effectively connected income. And then there's a regime that exists called the branch profits tax, which, and it will make more sense in a moment, seeks to put that U.S. taxable presence of the foreign corporation more or less on parity with the taxation of a domestic corporation. And that includes by reason of remittances back to the home office from the U.S., I'm just going to call it the U.S. branch of the foreign entity. If there's a remittance, there is a withholding tax that applies generally at a rate of 30% on that remittance. That's the branch profits tax. And that is supposed to be analogous to, although it's not perfectly analogous to, our dividend withholding tax regime. The dividend withholding tax regime, as well as others, so withholding tax on items of income, and I think very importantly, and perhaps most relevant here, would be payments of royalty income, fall under a different regime, the fixed determinable annual or periodical, or we call it FEDAP income regime. And that deals with payments of U.S. source income, generally of passive nature. So royalties, interest, dividends, as well as others, however, such as certain types of compensation and other things we'll talk about. Again, at a general rate of 30%, and we're going to talk about treaties in a moment. That regime can be more difficult to manage because there is less certainty around what may or may not be taxable in the hands of a foreign corporation. That's for various reasons. And therefore, for just to add to the reason why you might establish a domestic entity, it's because having a domestic entity helps to establish brighter lines around what can be subjected to tax. So the income of the domestic corporation will all be subject to U.S. taxation because domestic corporations are taxable on their worldwide income. And then to the extent that that domestic corporation makes a payment that is a withholdable payment to a foreign person, that payment will be subject to withholding tax at source, which again, we're going to talk about in a moment, could be reduced from 30% to a lower rate, depending upon the character of the income and the availability of treaty benefits that might be relevant. So that's just at the highest level, an overview of the difference between how a foreign corporation and a domestic corporation might be taxed. With respect to the FEDAP regime, as well as other considerations, we have a very extensive U.S. tax treaty network. Our tax treaties tend to follow OECD models or have many similarities, but all of our treaties are discreetly negotiated with partner countries. So they are one-to-one treaty relationships, and they are all distinct. There are different terms and conditions in every one of them. There may be similarities, but they are not identical. The existence of a treaty and the eligibility for treaty benefits, if it is possible to obtain those benefits, is really a critical element in determining how to structure any inbound, not just legal entity structure, but tax and operational flow structure of that group. Because the existence of a treaty and the benefits that are provided therein may make a very significant difference, not only to the U.S. taxation of U.S. source income, but also to the home country's ability to tax that income. So what I'd emphasize there is that U.S. tax treaties are designed to prevent, to the extent possible, and it doesn't always happen, but to prevent double taxation on the same item of income. It does not modify domestic country taxation of income, and it does not create nowhere taxed income. So that's something that people often try to see if they can get. That's not really the objective of a tax treaty. But a critical element in a U.S. tax treaty is this concept of a permanent establishment. So before I discussed how a foreign corporation is subject to tax on its effectively connected income, and the threshold for establishing whether there is a taxable presence of that foreign corporation is really quite low under domestic law. To the extent that a foreign corporation can take advantage of a permanent establishment position if it's deemed appropriate to do so, that permanent establishment provision creates a much higher threshold for, or in order for the U.S. to be able to tax the income of the foreign corporation in any way, at least from operations. That's not true with respect to the payments of dividends or interest or royalties. That's a little bit different. We'll talk about that. But the existence and availability of a permanent establishment provision can be very, very important in order to help protect the foreign corporation, which might be the shareholder, for example, of the domestic corporation, from being subject to tax itself in the United States in connection with certain things that it does. The treaty can also reduce the withholding tax that is levied at source, which is generally a final tax on income, from our statutory rate of 30% to something lower. If it's a dividend payment, dividend rates tend to be reduced to somewhere between 0% and 15%. Royalties tend to be reduced to 0%, but that is not always true. Sometimes it's 5, 10, or 15. But that 0 or exemption tends to be the rule. But then again, eligibility, the fourth point, qualification for treaty benefits and residence is critical. Very often we'll get questions about the eligibility for a treaty the question might start with, what is the rate that would apply to such and such type of income? That's the question. It's very straight, seems like a straightforward black and white question. And it might be, but then we must first ask and analyze the extent to which the person who will be receiving the payment is a resident of the treaty member country, and whether under the limitation on benefits article, which almost all of our treaties have, whether that foreign person qualifies for treaty benefits as a threshold matter, because there is a concept out there called treaty shopping. Sounds nefarious, can be, isn't necessarily. But to the extent that one does not qualify under the terms of the treaty, it does not even matter that you might be a resident of the member country. You might not be eligible to get that reduction in withholding tax rates and other benefits that the treaty might otherwise provide. So, withholdable payments, staying on theme. Withholdable payments may have different character, and depending upon the characterization of that type of income, the item of income will be taxed in different ways. And as an example of that, to the extent that a payment might be in the character of royalty, even though it might be described in some other way, like a license fee, for example, we'll often encounter the term license fee. But when you analyze what that license fee is in terms of how it's characterized for U.S. tax purposes, it may be a royalty, and you might be able to get a beneficial rate on that to the extent that there is a treaty in place, or otherwise it might be subject to 30%. In the alternative, again, depending upon the character, the predominant character of the item of income, that might really be viewed as something else. It might be more akin to a service. That service might be provided outside of the United States or from without the United States. And to the extent that it is, and that it is not otherwise effectively connected with the U.S., that payment for that service might not be subject to U.S. taxation at all. So we look to the substance, generally speaking, of a payment or the activities that give rise to the payment in order to determine the character of the payment and thus how that payment might be taxed under U.S. tax principles. And then those payments must be subject to U.S. source. So under our rules, we have very complex sourcing provisions, and those payments must also be made pursuant to the arm's length principle. So a transfer pricing agreement, or that for whatever your controlled transactions might be, is very, very, very important to have in place, well thought out, well executed, well documented, and having a transfer pricing study done with benchmarking analyses and something that conforms with our arm's length transfer pricing documentation requirements is generally really truly advisable. And that's it's an undertaking, but it's important. I'll touch lightly here on employees, agents, and independent contractors, because David already spoke about this a little bit, but I think key to keep in mind is that the form of an arrangement, it is not necessarily determinative. It is the substance of the arrangement that tends to be determinative. So I agree with David's comment that we often hear the term independent contractor used and thrown about. And when we look at the substance of it, certainly from a tax perspective, we may come to a different view and say that that person is an employee or a statutory employee or a dependent agent, something that gets someone who gets taxed in a different way because of how they really function and operate. But I also want to call out the concept of an accidental American, or what we call an accidental American. It's important to keep in mind that the physical presence of a foreign person in the United States, so someone who's a non-resident alien and who would generally expect not to be subject to taxation or to somehow be subject to limited taxation in the United States, that is a very easy thing to run afoul of. Most people have a sense that to the extent that a non-resident alien is in the United States for fewer than 183 days in a year, they will be protected from taxation. That is not necessarily the case because in addition to that, we also have something called a soft, or what people refer to as a soft physical presence test. And that requires us to look back over a 3-year period and to weight the number of days that an individual was in the United States and to determine based upon that weighting whether the aggregate is 183 days or more in the current year. And to the extent that it is, although in all of those 3 years, the individual may not have been in the United States for 183 days, they may have been over the 3-year period, and thus they may be considered to be a U.S. resident for U.S. tax purposes and have themselves exposed to the remarkably complex U.S. tax system in ways that they could not have imagined. And then my final other comment would be to consider who your shareholders are, or the owners of your foreign business, because we frequently find that owners of foreign businesses are themselves also U.S. persons. They might be dual citizens, they might have a green card, they might not be living in the United States, but they nevertheless might be considered U.S. persons for tax purposes. And that can create innumerable other considerations, not only with respect to them, but also the foreign business and the reporting of the U.S. business. So if you have a domestic corporation, it could have a host of other reporting responsibilities unto itself, as well as reporting responsibilities with respect to its ultimate indirect owners, if those are U.S. persons, for reasons that might have never come to mind for those people. So, some general comments. When you're seeking to enter the U.S., just keep a few things in mind, and these are really very much on theme with comments that have already been made. As part of your strategy development, please don't underestimate the importance and risks of taxation in the United States. Our system is systems, plural, is so remarkably complex that it is nearly impossible to navigate without qualified professionals to assist you. A foot fault can be inordinately costly. The number of taxing jurisdictions that we have is just simply innumerable. And you can really run into incredible problems associated with that. And in the same vein, again, complexity plus your compliance requirements are going to be incredibly significant, generally speaking, and complex, and therefore costly. So the costs associated with maintaining a tax structure in the United States is a common discussion point with those that I work with who are entering the U.S. because they tend to underestimate the level of complexity that they will encounter. Once I try to explain it to them, they have a better sense of things. And then when you fast forward a year or 2 years, they say, wow, it's even more complex than even what I understood after you told me about how complex it would be. So just please keep in mind that those costs are important to take into consideration when considering your entry into the U.S. So you do that extra work up front, as has already been commented, work with your advisors up front because they will help you make the best economic and business decision that you can. With that, I'll turn it back to David.
Terrific. Thanks, Fred. That was great. And if people have questions, please feel free to post them in the chat or in the Q&A or after the program. I apologize, we may not get time for questions during this session. If we don't get to them, then you can feel free to contact any of us directly. With that, I want to turn it over to Andrew Kidd of Poolworks. And he's going to talk to us about his experience in bringing his system, his company's experience bringing the system here to the US. And so if you could just start off, Andrew, by introducing yourself and tell us, I want to do this more as a little bit of as a Q&A, if you can tell us about how big the system is currently, and then tell us about the history of bringing the PoolWorks brand to the US.
Thanks, David. So PoolWorks is operating 400 units globally. We've just knocking on 100 units here in the US as we speak. If I look back at our brand's journey in coming to America, our founder, John O'Brien, always had the vision 30 odd years ago that when he created the brand in Australia, getting it to the US was important to him. So forming that brand was super important. There was at least 10 years of homework and strategizing and networking in the USA and being part of IFA and meeting with consultants and talking with US franchisors that made up part of that plan for us to execute entry into the US. If I look at, and maybe Ray probably did the overall summary of the different elements of the journey of coming to the USA, all gold, all absolute gold. And we've certainly found that, let me just talk a little bit about how being a global brand is helpful for us. So we stay very connected. So my counterparts in Australia and New Zealand business and myself, we're talking at least weekly. Our major departments are talking monthly. So we're staying in sync. But when you come to America and operate your franchise here, you need to be humble and you need to recognize it's time to be American and think American. And there's lots of really subtle little differences in terms of the business processes. There's any number of legislative and compliance issues that are completely different. But it's finding that balance of keeping your brand culture and essence, which you're bringing from another land, and finding a way of embedding that into the American way of doing business. The quicker you're known as not being a foreign brand and you're known as a brand in your own right in the USA, the better you will be. When you start out, all your legacy is what you've achieved in other places. And that's a great story. I mean, you're not coming to America to learn how to run a franchise. This is the home of franchising. If you haven't got franchising buttoned down in your business DNA when you get here, you're going to get your backside booted, right? For all the reasons that have been mentioned.
So Andrew, tell us, you were the chief operating officer of PoolWorks in Australia, and tell us about how did PoolWorks go about bringing their brand to the US?
Yeah, so we started off with an acquisition strategy. So we're in the pool service and retail supply segment. So we picked a couple of businesses in Arizona and Texas. They were independent operators. They were seen as strategic key markets for us in the pool space. So we acquired these independent businesses. We put our systems in place, rebranded the business. We tested our manuals. So having really good manuals in your home country makes updating and refreshing your manuals to suit the American market so much easier. But we realized it was very important to start to get some of those finer points right and to make sure that we're really Americanized in our operations and our processes and approach.
So I guess you had the advantage of you didn't have to make, well, you did make that choice in terms of whether to sell franchises right away or have company-owned locations. You effectively acquired company-owned locations by doing the acquisition, and so you didn't start in the U.S. selling franchises. You acquired companies, and those became your company-owned locations.
Correct. So it took about 18 months for us to transition to the point of single territory sales to the slides earlier. Another learning from us coming out of that acquisition is that we actually found a number of key operational executives that are still to this day part of our corporate support team.
Say that again?
So some of the employees in those businesses we acquired are actually still to this day part of our corporate support team, either in the field or trainers. They have our culture. So that cultural transfer into the PoolWorks way of doing business and philosophies started way back from those initial acquisitions in 2015, 2016.
Gotcha. So after you acquired the locations in the US, how long after that did you start selling franchises in the US?
Yeah, it was about 18 months.
18 months?
Yeah, we probably made a mistake, to be fair. We brought our FD sales team across from Australia because we know our brand well. We're good at
Right.
what we do. Selling franchises in America is a totally different animal. We were really sluggish to get out of the gates there, and I think it was just that whole approach, trying to pick up an Australian way of selling a franchise, dropping into US. We were doing it all in house, so there was no engagement with the franchise brokers, who are such a key channel in growing a brand in the US market. We didn't touch FSOs. We would try to do it all ourselves. And when I say that, be humble, recognize where your strengths are, but also recognize part of doing it in-house and not using brokers and FSOs is because cash is so critical. As a foreign entity entering the USA, we can't get a loan. We couldn't get an overdraft. We couldn't even get credit cards. You're totally reliant on cash flow from foreign sources to establish. So the thought of selling a territory and giving away some or most or all of that fee to someone
Right.
to generate that sale, when things are so tight at the beginning, was just a really struggle of a concept for us. But turn the clock to now, key part of our strategy, and that's why our brand's really moving right now.
So how do you sell franchises now?
Yeah, so we're doing probably 65% of our territory sales are via franchise brokers, and that's a big learning coming from another market where they're perhaps not a big part of the puzzle. They're bringing qualified candidates.
So you use the brokers to bring you the candidates, but then in terms of the sales process and getting them to sign, who's handling that?
Yeah. So we have an internal American expert franchise sales vice president who's running the internal part of the sales process, and we do some organic
Based in the
sales.
US.
100%. That was a change 4 years ago. Such a game changer in terms of our ability to transact.
In what way? To educate us.
They just get how American franchising works. They've got the hustle. They've got the connection. They know how to bring the brand to life and present it in a way that an entrepreneurial family will look at and say, "I want a piece of this."
Right.
It's a true business
And that
opportunity.
person is on like a salary and plus a commission kind of basis?
Correct. Yes.
Gotcha. And then how do you deal with providing the training to the new franchisors and the ongoing support? How did you do it at the beginning, and how has that changed?
So our first franchisees were sent to Australia for training. That's not a
Okay.
sustainable strategy long term. But we have our induction is called Pulse School. We've got a fantastic facility in Brisbane in Australia. And when we set up in Texas in 2018, we basically replicated that facility. So we've got
How
our
did
own
that work,
corporate
having them fly to Australia for the training?
It was
Work out
exciting
well?
for them. But again, we had Australian trainers training the Australian way. And we could get so far, but there's just every time you'll trip on those little those little details are the things that will really get in your way. So we've got a support team based in the US of 22, largely in Texas, but spread across the country. We've got our own training programs, in-field support. We're a full service franchise model. Big investment.
Those are salaried
Yep.
trainers?
Yep, no consultants. It's all internal employees. We're a 80% American workforce. And again, we probably took too long to stop bringing Australians here and to embrace the American way. And again, the business is moving forward much stronger and much more quickly the more Americans we have inside the brand here.
Terrific. What other advice or recommendations could you give from your experience to a non-US franchisor coming to the US?
I think to raise point, it'll take twice as long and cost twice as much. I think that was probably generous, probably 4 times. Be humble, be really open. I mean, IFA, we've been coming to IFA for 15, 20 years. It's been such an important part of our learning of how to get into the market. The consultants on finance, legal, and tax, so critical. And even now, we are coming up 9 years into the US. We're still seeing, thank goodness we took that step back then in terms of the tax structures that we set up, in terms of the FTD preparation and the attorneys that we've got to support us to avoid being in any legal stoushes so far. Be open and humble.
Great advice. Well, that's terrific. So we just have a few minutes left, and wanted to give people watching the opportunity to ask any questions. So I'll open it up for that. You can use either the chat feature or the Q&A button. If there's any questions, you could post them now. If you're watching this as recording, then I guess you won't be able to post any questions, but just open it up for that. And maybe while we're waiting to see if there's any questions, Ray, just based on everything that we've talked about, any other issues that you want to emphasize or touch upon?
No, it's always great to hear the experience of a franchisor who's been there and done that. So, Andrew, thank you so much for that. I have to say, I mean, it's a great brand, and you guys have done so well. 8 years ago, I started using PoolWorks for my pool, and they're still coming and cleaning, my pool every week. So it's a great success story, Andrew, and I'm glad you could be so open about the challenges. But boy, it's you guys have done a great job.
Andrew, how do you like living in Texas, and what was that like for you and your family to move from Australia to Texas?
Yeah, so we moved in 2019, so just before the previous election, just before COVID, all sorts of wonderful things. So it took a little bit of getting used to, I'll be honest, but we love it. We went through all the visa hurdles, which is part of that conversation that's been had. We're just about to go down the green card path. I've been really fortunate to see so much of this country. My role getting out, I'm at franchise development and sales is such a key part of my function as CEO when you're growing a brand in a new market. So we've got a fantastic team of support executives and franchise partners. We're at that great size where everybody knows everybody by name and probably the dog's name. And really appreciate the way that we've been embraced as a brand inside the franchising community. It's an exciting place to live.
Terrific. All right, well, we're coming up against the clock. Anything else any panel members want to bring up or emphasize? And I'm not seeing any questions right now, so I guess we'll wrap up. And again, I want to thank the IFA and the International Committee, and in particular Tao Xu, the Director of Programming. He's at DLA Piper, for initiating this program. Thank each of the panel members, Andrew, Fred, for your insightful tax advice, and Ray for your insightful recommendations on bringing a non-US brand to the US. So with that, we'll bring it to a close. And thank you, everybody, for attending.
Thank you.
Thank you.